I welcome Ranking Member Langford, members of the committee, and our witnesses. Today, we are examining the Department of Homeland Security's process for managing migrant arrivals at the southwest border and how this process has changed after Title 42 ended. From March 2020 to May 2023, DHS used Title 42 public health authorities to quickly expel more than 2.9 million migrants from the United States. When the Title 42 authorities ended on May 11, 2023, DHS started processing all migrants arriving at the southwest border under regular immigration authorities. This process is complex, and things like demographics and expression of fear all influence how a migrant is processed. And because the border is so dynamic, DHS's programs and protocols change frequently. Each of the components represented here today, Border Patrol, the Office of Field Operations, Enforcement and Removal Operations, and Citizenship and Immigration Services, play pivotal roles in this complex process. Border Patrol and OFO are on the front lines and are responsible for apprehension and initial processing along the southwest border. ERO is responsible for tracking migrants during the pendency of their removal proceedings, including through detention and alternatives to detention programs. And USCIS manages credible fear interviews and asylum applications. Any bottleneck or delay at any point in this process can have serious impacts on our border management system. Delays can cause overcrowding at CBP facilities, which can lead to unsheltered releases, also known as street releases in border communities. The Tucson sector is currently one of the busiest sectors in the country for migrant encounters, and the border communities in this sector are at high risk for street releases. As this subcommittee has explored in previous hearings, street releases cause serious harm to migrants and border communities. Congress needs to understand this process in order to modernize our border management system and keep Arizona families safe and secure. My border and immigration proposal with Senator Tom Tillis includes several important improvements to this process to ensure our border is secure and that migrants are treated fairly and humanely. Today's hearing gives us an opportunity to learn how this process has changed since the end of Title 42 and how these changes affect our border management system. I hope the information we gather today will motivate others to join us in advocating for common sense solutions to our broken border policies. I look forward to hearing from our witnesses today. And now I'd like to recognize Ranking Member Langford for his opening statement.
Senator Sinema, thank you. Thank you for holding this hearing. To our witnesses, thank you not only for being here today, all your preparation for today, your written statements that are in, your oral statements that are coming, but thanks for your service to the country. It's incredibly important. Everywhere I travel in Oklahoma, I have someone that stops me and asks me, whether it's urban or rural, how's it going on the border, what's happening with the system. People are concerned. There's 6 million people that have been encountered coming across our border just in the last 2.5 years, and people are exceptionally concerned about that. And they want to know what's happening and where things are going. This subcommittee's had several hearings dealing with immigration. We've dealt with GSA's management of the ports. We've dealt with social media and some of the illegal, illicit activities that are happening to recruit individuals coming across the border. This one in particular, I'm pretty excited about, actually. We've not had the opportunity to be able to sit down and talk about where is the process. Since the end of Title 42, there have been a lot of promises that have been made, but we really don't understand the full breadth of the process and what actually happens to each individual as they come across the border. We know bits and pieces of it, but some of the terms are new, and some of the terms, quite frankly, there's been a lot of working out on. The term rebuttable presumption is a new term that's actually out there that everyone's trying to figure out how does this actually work. There were promises that there would be a dramatic drop in the number of individuals crossing our border illegally. There were for about 6 weeks or so. Then, as just was reported by the Washington Post, we had the highest numbers of family crossings in the history of the country in August. So the numbers have shot back up and have shot back up dramatically. And all these questions about what's happening, how it's happening, there will be most of our questions will focus in on what is the process. What actually happens if an individual crosses at a port of entry, they're treated one way. Between a port of entry, they're treated a different way. If at a port of entry and they've done CBP 1 app, they're treated different than a person who just shows up with that one. There's now parole. There's also what's happening in separate with rebuttable presumptions. There's a lot of confusion on the process, and at the tail end of that, cartels are using that confusion to be able to push additional people coming across the border. We've got to be able to know what is happening, what is the process for each of those individuals, and what actually happens in a court setting in the days ahead for these individuals. So today's hearing will have the opportunity to be able to walk through all of those different scenarios and to be able to determine where do things go. A recent report from the USCIS Ombudsman highlighted some of the backlog issues and to be able to raise some questions about how these individuals can be vetted. There's been different numbers that have come out of late to be able to talk about the quantity of individuals and how many we can track and how many we can't track, those that are actually detained and those that are on the non-detained docket, and what happens to those individuals. So I appreciate everyone coming prepared, because we have a lot to be able to talk through today, and we'll try to get to as many practical things as we possibly can as we walk through this. So I appreciate the input from every one of you and look forward to not only your questions, but I'm going to go ahead and promise you I'm going to flood you with questions for the record as well, to be able to follow up on it and to be able to gather data as well. So I appreciate that very much. Thank you, Senator Sinema.
Oh, thank you, Ranking Member Langford. It is the practice of this committee to swear in witnesses, so if you would all please stand and raise your right hand. Do you swear that the testimony you will give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. We will now hear from our witnesses. I'll ask each of our witnesses to keep their remarks to 7 minutes or less, and your full written statements will be entered into the hearing record. I'd like to first introduce our first two witnesses representing Customs and Border Protection components, Chief David B. Miller and Mr. Matthew Davies, who will be jointly delivering CBP's testimony. Chief B. Miller currently serves as the Chief of Law Enforcement Operations for the U.S. Border Patrol in Washington, D.C. He's responsible for the oversight of day-to-day Border Patrol operations throughout the United States and in international engagements. He serves as the principal advisor to the Chief of the Border Patrol on enforcement operations, personnel, infrastructure, and technology requirements. Mr. Davies serves as the Executive Director for Admissibility and Passenger Programs within the Office of Field Operations, or OFO. In this role, he oversees multiple national-level programs related to admissibility enforcement and traveler facilitation, in addition to serving as a primary point of contact for engagement between the travel industry and the Office of Field Operations. Welcome, gentlemen. You are recognized for 7 minutes.
Good afternoon, Chair Sinema, Ranking Member Langford, and distinguished members of the subcommittee. It is an honor to testify today and discuss U.S. Customs and Border Protection's operations at our nation's ports of entry since the termination of the Title 42 Public Health Order. I am proud to represent the more than 30,000 dedicated personnel of CBP's Office of Field Operations, commonly referred to as OFO, who remained on the front line throughout the COVID-19 pandemic and who worked tirelessly every day across 328 ports of entry to protect our border, our homeland, and our communities. OFO must balance multiple complex mission sets, including the processing of inadmissible persons, facilitating lawful trade and travel critical to our nation's economy, and protecting our communities from dangerous activities of transnational criminal organizations. Today, I will summarize OFO's current operations for processing inadmissible persons and highlight our ongoing enforcement and facilitation efforts. OFO's current processing procedures for inadmissible persons at southwest border ports of entry developed from an approach that the Department of Homeland Security began implementing last year to manage the continued increase in irregular migration, and for OFO to ensure performance of our primary security and facilitation mission objectives. Starting in October of 2022, DHS implemented a process allowing certain Venezuelan nationals to travel to the United States by air to seek parole, which is granted on a case-by-case basis for up to 2 years. This process was expanded in January for nationals of Cuba, Nicaragua, and Haiti, along with a CBP-1 application feature enabling applicants to request advanced travel authorization via the app. To receive advanced travel authorization, these nationals must meet specified criteria to include having a U.S.-based financial sponsor and clearing CBP's rigorous biometric and biographic screening. As of July 31st, more than 181,000 Cubans, Haitians, Nicaraguans, and Venezuelans have arrived through this process. Building on this approach, on May 11th, when the Title 42 order ended and CBP resumed applying its full range of immigration authorities under Title 8, DHS and the Department of Justice implemented a circumvention of lawful pathways rule, establishing parameters and processes for asylum eligibility. The rule was implemented in conjunction with a new CBP-1 feature that allows non-citizens seeking to enter the United States to submit advanced biographic and biometric information and schedule an appointment with a CBP officer at one of 8 designated ports of entry for appropriate processing disposition under Title VIII, as determined on a case-by-case basis, considering the totality of circumstances. The CBP One app is just one example of how OFO is using innovative technologies to enhance the security and efficiency of processes at our ports of entry. OFO also continues to expand electronic A-file functionality across our operational footprint. This initiative allows CBP, ICE, and USCIS to share and maintain a single immigration case file in a digital environment, replacing a paper-based process. Prior to May 11th, OFO implemented electronic A-file processing for notice to appear and certain other Title VIII dispositions throughout the Southwest border field offices, including at the 8 ports of entry that inspect non-citizens with CBP One appointments. In August, 80% of the amenable inadmissible population encountered by OFO at the Southwest border was processed using an electronic A-file. The transition to integrated digital processing platforms as part of comprehensive border management operations enables OFO to create significant efficiencies for our officers, modernize our processes, manage our available operational resources, and pursue other mission priorities. While OFO continues to address irregular migration challenges, we also maintain a persistent focus on national and economic security. For example, we continue to combat the increasing threat of illicit synthetic drugs, especially fentanyl, being trafficked into the United States. To date this fiscal year, CBP has seized approximately 24,000 pounds of fentanyl nationwide, with most of it, 21,000 pounds, seized at our ports of entry. CBP is pursuing several strategic objectives to address this significant issue, including expanded partnerships and information management to deliver actionable intelligence, advancement of data integration and analytics to enhance targeting efforts, and focused law enforcement actions to disrupt and dismantle illicit synthetic drug networks. At the same time, OFO is facilitating growing volumes of international travel across all operational environments. In July, the number of travelers arriving by air into the United States increased approximately 18% when compared to the same time last year, while pedestrian and passenger vehicle traffic at our land border ports of entry increased by 12% and 11% respectively. We also continue to facilitate the flow of trillions of dollars in legitimate cargo every year through our ports of entry, while enforcing hundreds of trade laws that protect American businesses and consumers. As part of our planning for the end of Title 42, OFO surged resources, technology, and personnel to safely and efficiently manage challenges at the ports of entry, while maintaining a persistent focus on our other missions, including but not limited to interdicting illicit drugs and facilitating the flow of legitimate trade and travel to ensure continued national and economic security. I appreciate the subcommittee's continued support of our mission and our workforce, and I look forward to your questions.
Good afternoon. Good afternoon. Can you hear me? Good afternoon, Chairwoman Sinema, Ranking Member Langford, and distinguished members of the subcommittee.
I'm not sure that microphone is working. Oh, there it is. Okay, thanks.
Closer. It is an honor to testify today on behalf of the U.S. Border Patrol to discuss the operations along the southwest border, which since the termination of Title 42 Public Health Order. This past May, the U.S. Border Patrol celebrated its 99th anniversary. As we approach 100 years to this country, much has changed in the agency and throughout the world. However, during my 25 years of service with the U.S. Border Patrol, at least two aspects have remained unchanged. First, the Border Patrol mission has always been complex, demanding, and very dangerous. Second, the ability of our workforce to persevere even during the most challenging times. It is truly remarkable and a reflection of the agent's can-do attitude. There are three areas that I would like to focus on today. First, summarizing the Border Patrol's current immigration enforcement processes. Second, discuss our ongoing border security operations and initiatives. And third, highlight how we are addressing anticipated operational challenges. First, our immigration enforcement processes. While Title 42 was in place, it was part of a national effort to prevent the spread of COVID-19. During that time, the Border Patrol expelled certain migrants encountered between the ports of entry. While this aided in the streamlining the return of certain individuals, it also led to a higher level of repeat encounters. Since Title 42 ended, all migrants interdicted between the ports of entry are transported to Border Patrol facilities, processed in accordance with Title VIII authorities, and appropriate consequences are applied. This may include expedited removal and transfer to Immigration and Customs Enforcement. As part of our processing and intake procedures, the Border Patrol is committed to ensuring the health and safety of those in our custody, including providing on-site medical care and referrals to local medical services when necessary. The Border Patrol each Border Patrol sector faces its own unique challenge. Regardless of the circumstance or environment in which encounters occur, agents will continue to adapt to the ever-changing threats. Which brings me to my second point, ongoing security operations and initiatives. In addition to our immigration enforcement duties, the Border Patrol maintains a persistent focus on our mission objectives aimed at countering sophisticated and ruthless transnational criminal organizations, or TCOs. When it comes to combating drug trafficking, such as the deadly flow of fentanyl, Border Patrol has amplified its efforts to target and seize illicit drugs between the ports of entry. Recently, during a 2-month intelligence-driven operation, the Border Patrol seized nearly 2,500 pounds of fentanyl, along with thousands of other pounds of dangerous narcotics and weapons. These efforts are directed to protect the citizens and the communities of the United States. Additionally, coordination with our international partners inform information sharing on migration flows and drug trafficking activities. This increases our domain awareness and influences how the Border Patrol plans and leverages its resources. The Border Patrol also collaborates with our many local, state, and federal law enforcement partners to counter illicit activities of TCOs that prey on vulnerable migrants. All too often, smugglers abandon them in dangerous and life-threatening situations. To that end, the Border Patrol agents regularly conduct rescues and provide emergency medical care to those in distress. Our agents rescued over 37,000 migrants this fiscal year, including nearly 3,000 in August alone. This brings me to my third and final point. As we reflect on the past 99 years of the Border Patrol's history, and as we rise to the current operational demands, there are several complexities and challenges that I must address as we look forward. We must continue to invest in our workforce, provide them with the tools to face these extraordinary challenges head on. We also can't overlook the importance of our critical infrastructure and the significant role our facilities play in our law enforcement mission. While quick solutions are unlikely, our facilities, including our checkpoints, must be modernized to face the evolving threats without impacting trade and travel. And lastly, the most significant operational challenge facing the Border Patrol is that our agency is increasingly performing detention and processing related duties that are outside the scope of Border Patrol's frontline mission. While we should be focusing our efforts to combat the flow of illicit drugs and disruption of TCOs, much of the agent's time is spent transporting, processing, and detaining migrants. This substantially increases the risk of got-away traffic, including narcotics, terrorist, and other contraband. Border security is national security. In closing, the U.S. Border Patrol will not waver from our critical mission and will continue to serve and protect the nation with honor. I am grateful for the continued support of Congress and appreciate the opportunity to appear today, and I look forward to your questions.
Thank you. Our next witness is Mr. Daniel Bible. Mr. Bible is the Deputy Executive Associate Director for the U.S. Immigration and Customs Enforcement and Removal Operations, also known as ERO. Mr. Bible leads ERO in its mission to protect the homeland through the arrest and removal of non-citizens who undermine the safety of our communities and the integrity of our immigration laws. Responsible for a budget of approximately $4.4 billion, Mr. Bible directs operations of more than 8,600 employees assigned to 25 ERO field offices and headquarters in more than 200 domestic locations and 25 overseas locations. Welcome, Mr. Bible. You are recognized for 7 minutes.
Chairwoman Sinema, Ranking Member Langford, and distinguished members of the subcommittee. Thank you for your continued support for the dedicated and hardworking women and men of U.S. Immigration and Customs Enforcement and removal operations. I'm proud to serve beside them, and I'm grateful for the opportunity to appear before you today. ERO's mission is to protect the homeland through the arrest and removal of non-citizens who undermine the safety of U.S. communities and the integrity of the immigration system. While ERO primarily focuses law enforcement activities within the interior of the United States, border enforcement efforts during recent years have stretched ERO's resources. As a result, ERO must carefully balance its resources to continue to uphold its mission in the face of changing operational conditions and new demands, including significant shifts in the post-Title 42 environment. During implementation of the Title 42 Public Health Order, ERO worked closely with U.S. Customs and Border Protection to support enforcement operations at the southwest border. As CBP conducted Title 42 expulsions at the border, ERO conducted Title 42 expulsion flights while continuing to remove amenable non-citizens under Title 8 Immigration Authority. From March 2020 until May 11, 2023, ICE assisted in more than 184,000 Title 42 expulsions. ERO also provided direct and sustained support for DHS efforts to decompress border facilities. In FY22, approximately 1,000 ERO employees were detailed to the southwest border to process cases and offer transportation for non-citizens apprehended by CBP to alternative to detention locations, ICE facilities, and as appropriate. ICE's bed space inventory is being constrained by the increase of detention facility closures, pending litigation, and court decisions, and state laws that hinder the use of contract facilities. However, ICE has taken several steps to align its detention capacity with operational needs in the post-Title 42 environment, including increasing resources to release non-citizens with positive, credible fear determinations in a safe, humane, and timely manner, leveraging alternatives to detention, and focusing detention resources on non-citizens who are subject to mandatory detention, pose risks to public safety or national security, and may be flight risks. In the post-Title 42 environment, DHS has increased use of expedited removal under its Title 8 authority. Once apprehended by CBP at the border, or arrested by ICE in the interior of the United States, non-citizens subject to expedited removal may be detained by ICE. If non-citizens subject to expedited removal indicate that the intent to seek asylum or claim fear, they are afforded a credible fear interview with USCIS officers while in ICE custody. If USCIS determines the non-citizen has failed to establish a credible fear, ICE continues to prepare for expedited removal. If USCIS determines that the credible fear has been established, the non-citizens are generally released from ICE custody. Nevertheless, by expediting the review of asylum claims of non-citizens and expedited removal proceedings, no matter if positive credible fear findings exist or not, DHS is able to provide relief more quickly to those non-citizens who are eligible and to more quickly remove those non-citizens who are not. Over the past fiscal year, ICE began to operate several programs geared toward the fair, humane, and expedited processing of family units. In May 2023, ICE announced the implementation of the Family Expedited Removal Management Initiative, referred to as FIRM, for family units apprehended at the southwest border who are processed for expedited removal and have expressed a fear of persecution or torture. Through FIRM, certain family unit heads of households are placed on alternatives to detention and are closely supervised while the family awaits a credible fear interview. By the end of the month, FIRM will be operational in 40 cities nationwide. Over the past 18 months, ERO has also increased its removal flight capacity. The number of international charter flights conducted by ICE Air operations has increased more than twofold in the latter half of FY23 compared to the first half of the fiscal year. Removals via commercial airlines have also increased in the post-Title 42 environment. As of August 12, 2023, ICE has completed 4,282 commercial removals, an 85% increase from the same period in FY22. ERO remains committed to protecting the United States through the arrest and removal of those non-citizens who undermine the safety of U.S. communities and the integrity of U.S. immigration laws. In preparation for the termination of Title 42 and changes in migration trends, ERO took several steps to ensure the agency would continue managing all aspects of the immigration enforcement process, including providing CBP with logistical support at the southwest border, increasing the agency's transportation capacities, developing and operating several family-focused programs geared towards the fair, humane, and expedited processing of family units, increasing the use of expedited removal under ICE's Title VIII authority, and reinstituting the civil immigration enforcement priorities. ERO's efforts to allow agencies to ensure fair and humane immigration systems while fulfilling its critical national security and public safety mission as well. Thank you again for inviting me to testify today, and I look forward to your questions.
Thank you. Our final witness is Mr. Andrew Davidson. Mr. Davidson is the Acting Deputy Director for the United States Citizenship and Immigration Services. In his permanent role, he serves as a Senior Counselor for Humanitarian Programs in the Office of the Director. Previously, Mr. Davidson served as the Acting Deputy Associate Director of the Refugee Asylum and International Operations Directorate and is the Chief of the Asylum Division of the Directorate. Welcome, Mr. Davidson. You are recognized for 7 minutes.
Chair Sinema, ranking members Langford, members of the subcommittee, thank you for the opportunity to appear today together with my colleagues from U.S. Customs and Border Protection and U.S. Immigration Customs Enforcement to discuss how the Department of Homeland Security processes non-citizen encounters at the southwest border. My name is Andrew Davidson, and I'm the Acting Deputy Director of U.S. Citizenship and Immigration Services. My testimony today will describe the role of USCIS at the southwest border, and particularly how USCIS processes non-citizens in CBP and ICE custody and has operationalized the circumvention of lawful pathways rule. USCIS administers the nation's lawful immigration system, including the adjudication of affirmative asylum claims and applications for refugee status. USCIS employees work shoulder to shoulder with their ICE and CB colleagues, from conducting protection screening interviews at DHS facilities to coordinating on national security and public safety issues. USCIS has a proud history of providing immigration benefits to eligible individuals from all over the world. These benefits support the fundamental values and needs of our nation, be the economic, humanitarian, and otherwise in the public interest. USCIS delivers these benefits while ever being vigilant for those who seek to undermine the integrity of our immigration system, or worse, those who seek to do us harm. USCIS is only able to accomplish this complex and vital mission through the efforts of its thousands of dedicated public servants who each day administer a complex immigration system fairly and professionally. For more than a decade, the steadily rising influx of migrants across the southwest border has resulted in significant increases in apprehensions and the numbers of non-citizens placed into expedited removal. USCIS screens individuals for credible fear in some situations as part of the expedited removal process and plays an important role in ensuring that potential asylees or victims of torture are not improperly returned to their home countries in contravention of our laws, while those who are found ineligible are expeditiously removed. Our specially trained asylum officers conduct screening interviews for non-citizens who express a fear of return or otherwise express a fear of persecution or torture or indicate intention to apply for asylum during the expedited removal process. The screening interview is conducted to determine whether the non-citizen has a credible fear of persecution or torture. Non-citizens who meet the credible fear threshold may be retained by USCIS for an asylum merits interview to adjudicate the asylum application, or may be placed in removal proceedings in immigration court where they can apply for asylum or other relief or protection. Individuals found not to have a credible fear of persecution or torture may request a review of the finding by an immigration judge. Over the last 10 years, as irregular migration to the southwest border has increased, the number of credible fear referrals to USCIS has sharply increased as well. Approximately 35,000 detained credible fear cases were referred to USCIS in fiscal year 2013. USCIS has seen that number more than triple to approximately 107,000 so far in fiscal year 2023 as of August 11th. About 51,000 of these cases have been received since May 12th, 2023, after the expiration of the Center for Disease Control and Prevention's Title 42 Public Health Order and the return to processing of all non-citizens under long-standing Title VIII immigration authorities. USCIS has pursued a number of strategic strategies to address the increased caseload, including significantly expanding authorized asylum officer positions, deploying employees who had been previously protection trained from across USCIS to assist in the credible fears caseload, and maintaining remote interview capabilities. Our ability to process credible fear cases timely saves valuable DHS detention resources and enables the entire expedited removal process to operate more efficiently. USCIS remains strongly committed to supporting the government-wide response to the migration flows on the southwest border, including ensuring those who seek protection are provided the opportunity to have those protection claims heard. At the same time, USCIS remains committed to detecting and deterring immigration fraud, including within the asylum and humanitarian benefits. The Fraud Detection and National Security Directorate within USCIS has embedded teams at each of the 11 asylum offices. These local teams conduct pre-interview screening, provide on-site consultation to asylum officers interviewing applicants, analyze trends in large-scale fraud schemes, and serve as local liaisons to interagency law enforcement partners. USCIS continues to lead an asylum fraud working group within the interagency, and in recent years, USCIS has supported multiple successful criminal prosecutions and convictions involving asylum fraud, further demonstrating the department's commitment to ensuring the overall integrity of the immigration system. Over the last few months, DHS has implemented new measures of humanely managing the southwest border by enforcing our immigration laws while expanding safe, orderly, and lawful immigration pathways. The comprehensive approach is outlined in the DHS six-pillar plan. One of the enforcement measures implemented is the use of expedited removal. To ensure that expedited removal, including the credible fear process, is carried out fairly efficiently and quickly, USCIS worked with ICE and CBP to digitize part of the credible fear process and reallocated staffing resources so that hundreds of additional personnel were available to process credible fear interviews. Additionally, certain non-citizen populations are now processed for expedited removal while they are in CBP and ICE facilities within days or weeks after they're encountered. Through these measures, DHS provides relief more quickly to those who are eligible and removes those who are not. On May 11, 2023, the Circumvention of Lawful Pathways Rule took effect. This rule encourages migrants to use lawful, safe, and orderly pathways to enter the United States and imposes a rebuttal presumption of ineligibility for asylum for certain non-citizens who fail to do so. The CLP rule provides exemptions for non-citizens from the presumption of asylum ineligibility and allows non-citizens to rebut the presumption of asylum ineligibility by demonstrating exceptionally compelling circumstances. When a non-citizen attends their credible fear interview with USCIS, an asylum officer will assess whether the non-citizen is subject to the CLP rule, and if so, whether an exception applies or the presumption of ineligibility can be rebutted. USCIS will continue to respond to its rising numbers of credible fear referrals by ensuring DHS follows the laws written by Congress, swiftly processing non-citizens so they may either seek relief before an immigration judge or be expeditiously removed. Thank you for the opportunity to testify. I look forward to answering your questions.